The Maricopa County Attorney's Office has turned down a case involving a Buckeye High School principal who was arrested last week. Joe Kinney was accused of luring a minor for sexual exploitation. Officials say he thought that minor was a 12-year-old girl when in reality it was an undercover officer. The Buckeye Union High School District Governing Board met yesterday and still voted to fire Kinney. The community is left with a lot of questions. A spokesperson for the county attorney's office said the crime of luring requires proof that the suspect knew or should have known that the person he was communicating with was a minor, adding prosecutors require evidence that the suspect intended to follow through and engage in sexual conduct with a minor. There was no such evidence in this case. So let's take a legal deep dive. Joining me now is criminal defense attorney Hector Diaz of Diaz Law. All right, Hector, we said earlier the county attorney's office, they declined this case just because they didn't think that there would be enough evidence. Explain why.
So the county attorney has access to a lot more communication, a lot more text messages that they no doubt reviewed in this case, and they felt that in reading some of the information that's public, he likely knew or should have known that he was communicating with somebody who was purporting to be under the age of 12. Where I think the issue came down is whether or not he intended to follow through with the conduct. That's where it appears that there was some issue there, and the county has to look at it. They ultimately, if they're going to charge this case, they act as if they're going to go to trial on it. Even if they offer a plea, they have to feel comfortable that they can get a conviction. After reviewing all the information, they felt that they could not.
Okay, so obviously there wasn't enough proof, but explain the crime of luring. Where did that fall?
I think what's important here for this discussion is that he intended. There was really no evidence, at least from what we've gleaned thus far, that he intended to follow through, that he intended to meet up with this person who was, again, let's set the stage. This was an undercover police officer. You can actually be charged with this offense when the person you're communicating with is in fact not a minor. But there has to be some effort to show intent on the person to engage in that sexual conduct. And often in these cases, you'll have some communication that says, hey, you know what, we should meet up at, my apartment or at this house or et cetera. And what you glean from the information is that the county didn't feel comfortable that they had that component. Now, I think what's important to note here is that they executed search warrants at this individual's homes. They likely secured computers, cell phones. There's no question. I mean, we're talking about the FBI. They're going to look at these devices and see if there were other communications, potentially illicit images that he had on these devices. And so it's very possible we haven't seen the end of this.
Okay, it may not be over.
Right.
All right, Hector, thank you so much for your insight.